And the Law Society of Kenya has declared the current National Assembly and the Senate as illegitimate and claims all bills passed by Parliament are illegal. The society, which marched to Parliament buildings on Monday afternoon, claimed the President has no option but dissolve Parliament as advised by the Chief Justice, as failure to implement the 2/3 gender rule amounts to a travesty to democracy. Monday afternoon, and the area around Parliament was under tight security as LSK, together with other interested parties, marched to petition legislators to cease operations. Led by Nelson Havi, the lawyers' body claiming 14 days had lapsed since the President was handed the advisory by Chief Justice David Maraga to dissolve Parliament.
We have told the clerk of the National Assembly that effective today, Parliament is illegitimate. Any person who until today was an elected member of the National Assembly or the Senate has ceased being an elected member. He or she is a trespasser.
LSK claims the Houses had failed the people of Kenya, citing failure to pass the 2/3 gender rule, failure to oversight executive, corruption and nepotism.
The majority view of the people of Kenya is that Parliament has failed in its obligations. There is rampant corruption, there is nepotism, there is cronyism, there is no development. And we are not limiting our struggle to the 2/3 gender rule. There are many other reasons as to why Parliament must go home. It has failed to oversight the executive. It has failed to hold the President accountable.
He said the decision by government to file a petition in court halting the advisory was a delaying tactic, alleging that the government had failed to honor other court orders and should not be entertained.
Parliament and the Attorney General are buying time through the court process, or they have ensured that the court process will deliver an outcome favorable to them.
LSK vowing to continue lobbying for the exit of the legislators to ensure the Constitution is followed to the letter.
But more importantly, Kenyans must understand the decision by the Chief Justice is one that cannot be challenged in a court of law. Just as none of us can take the President of the Republic of Kenya to court because of a decision he has made.
Earlier in the day, the Law Society of Kenya filed a petition challenging the new security measures issued by the National Security Advisory Council and approached by the Cabinet to regulate public gatherings. The society is seeking to include orders restraining the Inspector General of Police acting by himself or his agents under his command from seeking to license or holding of public gatherings, meetings and processions, banning, disrupting or interfering with peaceful public gatherings, meetings and procession of LSK. It claims enforcement and implementation of the directive will violate the rights and freedoms of LSK and its members.